My name is James Gourley. I'm here on behalf of the defendant's appellants in this case, and may it please the court. So we're here today mainly because we believe the district court did not correctly apply this court's en banc holding in Veek versus SB CCI. I also want to talk about fair use, but first, I'd like to focus a little bit on Veek. And, what did Veek say? The opinion in Veek said, when Veek copied only the law of Anna and Savoy, Texas, which he obtained from SBCCI's publication, and when he reprinted only the law of those municipalities, he did not infringe SBCCI's copyrights in its model building codes. And that's basically identical to what happened in this case. And how did Veek get there? Veek is a long, detailed, thoughtful opinion that this court decided deserved a detailed treatment.
You said basically, did you only publish the materials that were adopted into law in Canada?
Right. So the code wholesale is adopted as law, the entire thing. The laws in Canada don't distinguish between parts that are not adopted and parts that are adopted. So the code is adopted as law. That there's really no way to know the law of Canada unless you see the entire thing. And there was no allegation that any portions, and there was no allegations made by CSA that any portions of the codes that were not law were copied. That was never alleged in this case. So how did Veek get there? It used two separate rationales. One was based on merger, and Veek said that under the merger doctrine, when an idea is susceptible to only one form of expression, 17 U.S.C. 102B excludes that expression from the Copyright Act. So it relied on Section 102B. It also relied on the Supreme Court decisions in Feist and Harper and Rowe. And the reason 102B is actually really important here is because 102B defines the extent of copyright protection in the United States. It says copyright protection does not extend to ideas, processes, systems, things like that. And the reason that's important is that the Berne Convention says that United States law exclusively governs the extent of protection. So you've got, I'm quoting there, the extent of protection is governed exclusively by U.S. copyright law. 102B says copyright does not extend to. So it's defining the extent of protection. So this court's precedent in Veek is directly applicable under the Berne Convention. So how did the district court deal with Veek? Well, not very well, again, in my opinion. First, the district court decision basically tried to limit Veek and the Southern District of New York case in upcodes to only applying to laws adopted in the United States. But there's no reason to limit those decisions that way, especially under the merger doctrine. This court said in Veek that the Constitution is a fact. The Texas Uniform Commercial Code is a fact. The codes of Anna and Savoy, Texas are facts. The law of Canada should also be a fact under that reasoning. It's exactly like that list that was enumerated in Veek. That there's no reason to just cabin it to things that happened in the United States. A fact is a fact. And this court said that the laws are facts, and that under 102B copyright protection does not extend to facts. So I think the court got that wrong there. The other thing the district court got wrong is sort of framing this more as a case about ownership of the copyright. Veek acknowledged that SBCCI owned copyrights in its codes. Upcodes, the decision in Southern District of New York, acknowledged that they said it was undisputed that they owned copyrights in their codes. What Upcodes said is that the controlling authorities make clear that a private party cannot exercise its copyrights to restrict the public's access to the law. Okay? So they can own a copyright. That's fine. They can't enforce it. They cannot sue somebody for copying the law of Canada under Veek, up codes in every other, case that's ever considered it. So, so that's another thing that the district court got wrong. The other thing, sort of going to your question, the district court said that basically the defendants didn't show that they published the law as opposed to the codes. But like I said, I can read the law. They're in the briefs. The code, the law of Canada says that not only are the Canadian Standards Association codes adopted as law, but that CSA can also amend those codes, and those amendments also become law. So it's just not possible to know the law of Canada without having access to the entire code as published by, because that's used in the law of Nova Scotia, as published by CSA. And not only that, CSA accuses us of copying the codes in the complaint. And I don't know that it's ever really been disputed. Like I said, I don't know if there was ever any allegation that there was some sort of like portion of the code that was copied that had not been adopted as law. And the other thing the district court got, I don't know that the district court actually.
Let me ask you a question.
Yeah.
I should know the answer to this. How in Canada did this actually get adopted? Was it province, or was it the whole Canadian government, or what?
I believe it's adopted in all of the provinces and federally. And the CSA's corporate representative in his deposition said that it's been adopted throughout Canada. And their complaint also says that it's been adopted throughout Canada. So it's the law of Canada. And another way that the district court tried to distinguish this case was by citing to 17 U.S.C. 105, which excludes copyright protection for works made by the United States government. But that's not what Veek cited for support. Veek cited 102B. And I don't believe the district court even cited 102B when it was discussing this aspect of the case. So the district court was relying on a completely different section of the Copyright Act to find against this.
Well, does that, we occasionally get district courts that stray, at least as we see it, maybe not correctly, but does that make a difference here?
No, as a matter of fact, the majority opinion in Veek actually relied on Section 105 to support its conclusion. It's basically said, look, if works by the U.S. government are not copyright protected, it kind of follows that these state laws and state codes are also not copyright protected. So it was like supportive of it. Veek actually found that 105 was supportive of its analysis, not contradictory. So, and then so that was all merger. Okay. The other justification used by Veek to find that SBCCI couldn't enforce its copyrights was based on this idea that the public is basically like the author of the law. So they acknowledged that SBCCI did author the codes, but once they're adopted as law, it's basically like the public wrote it. That's how they treated it, just conceptually. But the thing about this case is Canadian government employees were actually involved in drafting the codes here. It wasn't even, that's one of the things that the Canadian federal court found, as a matter of fact, in a previous litigation between these parties in Canada, was that these employees of these regulatory bodies and federal government agencies actually contributed to the code. So Veek is actually, the reasoning of Veek is actually even more supported in this case, because you do have some amount of government authorship involved here. So, it's a committee, so there's not really probably clear, who did exactly what, but government employees did contribute here. The Canadian courts found that. So that's all I have on Veek. Unless you have any other questions, I'd like to move on to fair use with the time I have. So the district court also found against my client on its fair use defense as a matter of law of summary judgment, and really it did so by focusing, I think, unfairly on factor one and letting factor one infect the entire analysis. Factor one is the purpose and character of the use, and basically because my client was selling copies of the code instead of giving them away for free, like ASTM, like the ASTM line of cases, and even VEEC, as a matter of fact, that the district court just found the ASTM case from the District of Columbia Appeals Court. He found it inapposite, just I think solely based on that idea. But that's only one character, the one factor. So the Supreme Court has said repeatedly that the commercial nature of the use is one factor and it is not determinative of the fair use analysis. And I hope you all saw my Rule 28 letter that cited an additional ASTM fair use case out of the DC Circuit. So now we've had 5 judges, because there was one overlap on those 2 panels. Now 5 judges have looked at this idea of model code adopted as law and fair use. 5 judges in the DC Circuit Court of Appeals have found that it's fair use when you make copies. Of course, like I said, in that case, it is different from this case because they were giving away for free, and here we are selling them. So that is different. But the other factors are identical. Factor 2, the nature of the copyrighted work. The ASTM cases persuasively, I think, say that these works are factual in nature and entitled to very, very limited protection under the copyright law. And by the way, that also supports the idea that there's merger under 102. And in fact, one of the concurrences in those ASTM cases was by Judge Katsas, and he actually strongly hinted that 102 would preclude copyright protection here as well. But he said since the majority was kind of, or the rest of the court was, wanting to limit it to fair use, he said that he thought that was appropriate, but he strongly hinted that 102B would also apply here. Under factor 3, the ASTM cases, acknowledge that basically the entire code was being copied, which, if you just read factor 3 might weigh against it, but the amount and substantiality of the codes that are used is required. I mean, you have to copy the whole thing if you're going to know the code, if you're going to know the law. So they didn't find factor 3 against the accused infringer, because to know the law, you have to copy the whole thing. It's just kind of the nature of the work. And then factor 4, there's no evidence of market harm for this work. In the ASTM cases, there were actually 3 model code drafters involved in that case on the plaintiff's side. Not one of them could identify any market harm, despite years of litigation. And the ASTM case that I cited in the Rule 28J letter acknowledged that. They said, look, they couldn't produce a bit of evidence of market harm. And the same is true here. The CSA's corporate rep testified that they've been able to update the codes as they usually have. They made an allegation in their complaint that the Canadian Electrical Code is one of their best-selling works. I asked him in the deposition if he had any evidence that wasn't true. He said no, so it's continuing to be one of their best-selling works. And he was also asked if he had any evidence of lost sales, and he said, I'd have to look into that. So that's evidence, I believe, of no market harm here, very similar to the ASTM case. I think that if this court were to find the ASTM cases persuasive, again, factor 1 may come out differently because we're commercial here instead of giving it away for free in the ASTM case. But I think the other factors weigh heavily in our favor, strongly in our favor, which is the language used by ASTM. And I think if this court looks at those cases and finds them persuasive, that the fair use determination by the district court could be overturned. And I'm out of time. Thank you.
Thank you, Mr. Gourley. You've reserved time for rebuttal. Ready to proceed? Mr. Parks?
Good afternoon. May it please the court, my name is Michael Parks, excuse me. I'm here with my colleagues, Catherine Colvin and Alex Whitener. I want to start by dispelling a fundamental misconception that's been at issue in this case, at least for the appellant's oral argument. CSA's codes are not the law in Canada. That's clear from the record in this case. And I can quote from Record on Appeal, page 4574, where the Canadian federal courts held expressly, the fact that the Standards Council has recognized the CSA electrical standard as a national standard and that the CSA has been accredited by the Standards Council does not transform the CSA electrical code into a statutory instrument. Likewise, at Record of Appeal, page 4577, the Canadian Federal Appeals Court holds, for the same reasons set out above in the context of the Statutory Instruments Act, the CSA electrical code is not a regulation and consequently not an enactment within the meaning of the Interpretation Act and the reproduction of federal law order. Canada has made the decision that CSA's codes are not the law in Canada. Canada also has made the decision that materials incorporated by reference into the statutes retain copyright protection. This case is not about the American Edicts Doctrine, the Government Edicts Doctrine. There is no such doctrine in Canada. That's solely a US creation. This case raises a very limited issue of whether a defendant in a copyright case over Canadian copyrighted works can evade the judgments and injunctions entered against him by the Canadian courts by relocating his operations to the US and doing the exact same thing from the US and continuing the infringement from here. The district court correctly ruled that comity and collateral estoppel do not permit the defendant in this case to relitigate issues of Canadian law decided against them by the Canadian federal courts. And the only issues governed by US law here weigh decidedly in CSA's favor.
What did the Canadian court actually hold? I should know that, but I don't.
The Canadian courts held that CSA's works are valid copyrighted works, that they do not become part of the law by being incorporated into the law, and that even if they had, Canadian law protects works that are incorporated by reference. And the Canadian courts also held that every single one of the works at issue in this case was infringed by the appellants. I want to focus on 2 points. The first is that the district court's decision was completely in line with this court's en banc decision in Veek and completely supported by that decision. Second, there is no fair use in this case. This case is nothing like the ASTM case that was the subject of appellant's Rule 28 letter. This is a case about the appellant trying to profit unfairly off of our works. This has nothing to do with trying to do something good.
What should they have done
They
to do it right, as you see it?
They should not have copied CSA's works. If they wanted to copy the law of, let's say, Alberta, they could have copied the Alberta statutes. That's not what they did. CSA publishes books with its codes in them. That's what the appellants copied, those books. They didn't go, for example, and say, hey, here's the law of Ontario, here's the law of Alberta. We're going to copy that and put that on our website. They're two separate things, and the district court made that clear. In terms of Veek, the opposing counsel made an argument that CSA's works are not protected because they somehow have merged into facts into law. The Veek and Bonk decision was very clear that issues of copyrightability are governed, this issue of merger is an issue of copyrightability. Issues of copyrightability are governed by foreign law, here Canada law. And the district court recognized that and applied Canadian law to those matters that the Canadian courts had already heard and decided in CSA's favor. Again, the merger issue relied on so heavily by appellants is an issue of copyrightability decided by the Canadian courts in CSA's favor. And at this point, appellants are collaterally stopped from relitigating those issues because they were already litigated in the Canadian federal courts.
So do you read Veek to be more about copyrightability or infringement or both?
I read Veek to be about both. On the copyrightability side, as I just said, it's a question of foreign law. On the infringement side, the major distinction with Veek in this case is that Veek was focused on items that had become part of a U.S.-based law. In this case, the laws of 2 towns in Texas. There is no dispute that none of CSA's works are incorporated by reference into any U.S. federal law. They're not incorporated by reference into any U.S. state law, nor any local law. So Veek's holding of why there was no, recognizable infringement does not apply to the facts of this case, because this case does not involve anything that's a part of any American law. And that was the premise of Veek's holding as to why infringement could not go forward. It's really important to note here that
A minute. Tell me what, in those 2 towns, I forget the name of them.
Anna and Savoy,
There you go. What did they do, to so as to get this stuff in their law? What, if anything, did they do to get it in their law?
so what happened is that the defendant in that case, SBCCI, I think is the correct acronym, gave copies of the codes to those towns, and those towns literally incorporate that exact text of those codes into its laws. And so when Veek copied the works of the plaintiff in that case, or the defendant in that case, what Veek was copying was really the laws of those towns. He copied the laws of those towns, which happened to be the same text as the work of SBCCI. That's not a situation like this case as the district court held, because again, the appellants Knight did not copy the law of any province in Canada. They copied CSA's books, the distinction that the district court found. It's really important to note and keep in mind why this case is in this court. This case does not come here on a clean slate. This case comes after 10 years of litigation in the Canadian federal courts. Knight, the appellants, they were enjoined by the Canadian federal courts from doing exactly what they're doing here now. They've been held in contempt by the Canadian federal courts for ignoring those orders. What they did, and they announced this publicly, they were proud of it, they boasted about it, that they moved their operations to the US outside the reach of the Canadian federal courts. And they said, I'm gonna sell my codes here for 1/2 to 1/3 the price as CSA's codes. What they also did, and this is very important too, when they came to the US, they actually registered a US copyright registration and CSA's electrical code. And they obtained a registration. The district court ordered that registration canceled because it was fraudulently obtained, because it wasn't their work. But when they registered it, they said, and this is in the record, it's in our brief, they said, we now have come here and registered CSA's code. They didn't register it in the US. They forgot about the Berne Convention aspects of the case. And they took the position that CSA's code is now the property of Knight. So at one point, they clearly thought the code was copyrightable because they registered it and got a copyright in it. It is only now that they've been sued in litigation that they're taking this position that there's somehow something wrong with these copyrights. If they really believed these codes were not copyrightable, they would not have gone to the U.S. Copyright Office to register them.
Well, you'd like to think not, but maybe they would have. That happens. That's why we're here, I guess.
The thing that I would really want to emphasize is that there is no fair use here. This case is the opposite of a fair use case. This is a case where the appellants, Knight, admit that they are trying to undermine CSA sales of its codes. They don't give them away for free. They sell them for 1/2 to 1/3 the price in order to undercut CSA's price. This is nothing like the ASTM case, where the defendant in that case, gave the codes away for free. There was no charge for it. This case is not that type of case. There also has been market harm to CSA, and we pointed this out in our brief. The district court went through and found examples that we pointed out of the market harm. There were emails that the defendants in the case produced that showed that there were numerous people who were buying their infringing works over CSA's works, and that is going to destroy the market for CSA's works. Another potential problem here is with this notion of being able to just copy works that are standards, there's no way to retain quality control over it. You know, when people copy, they make errors. These standards get used for some type of electrical work or whatever it may be. That could be a serious problem. If there's not a mechanism to stop people from copying, it's more than just a financial market harm. It also is a potential danger to folks who may be trying to use these standards in their operation. Again, this is not and should not be a complicated case. It was already decided by the Canadian federal courts. What we have here in the US is basically a rerun of what the Canadian federal courts have already decided. There is nothing in this case that has anything to do with any US law. This case has nothing to do with the government edicts doctrine. This case presents no public policy for the US. Canada has its own public policy about what is and is not a law within their country. The US has its own policy about what is and is not a law within its country. But nothing in this case gives rise to dictating what Canada's policy could or should be about what it considers to be the law. And Canada's been very clear that CSA's codes are not the law in Canada, nor is there any public policy reason to dictate what is or is not copyrightable under Canadian law. And again, Canada has made the decision that even if CSA's codes were the law in Canada, which they are not, Canada still gives copyright protection to matters that are the law in Canada. So there's no reason to do anything here but to affirm the district court's well-reasoned 39-page decision that stepped through all of this and permanently enjoined the appellants from further infringement after looking at this entire record and recognizing that this is just a matter of bad faith on the part of the appellants trying to use the US court system to circumvent what has been decided against them very clearly by the Canadian trial court, affirmed by the Canadian appellate court, and then leave to appeal was denied by the Canadian Supreme Court. This cannot be a more simple case to affirm the district court on. And unless your honors have questions, I'm happy to yield the remainder of my time back to the court.
Thank you.
Thank you. May it please the court. I just wanted to make a couple of points. So I believe there was sort of a representation there that the accused infringer in Veek was actually copying the text of the law of Anna and Savoy, and that's not the case at all. If you look at the district court decision in Veek, it said, and I'm quoting here, Anna and Savoy, Texas, under expressed agreement with SBCCI, have enacted ordinances adopting SBCCI's model code by reference. So it was adopted by reference. It basically just said, look, SBCCI's code is our law.
How do you respond to Mr. Park's argument that their codes have not been adopted into law?
Well, they have. I can read you the quotes here. So the electrical code regulation of Alberta states as follows. The following codes, as amended or replaced from time to time, are declared in force in respect of electrical systems. A, the CSA standard C, 22.1-18, 2018 Canadian Electrical Code, safety standard for electrical installations published by the CSA group. The electrical code regulations of the province of Nova Scotia says that the code means the latest issue of the Canadian Electrical Code, Part 1, published by Canadian Standards Association, current issue of which is CSA Standard C22.1-2002, as supplemented, amended, or added to from time to time by the Canadian Standards Association. It's identical to Veek, how they're adopting it as law, by reference. So that's one point that's very important. The other point is that they filed a lawsuit under U.S. copyright law. It says it in their complaint. The Berne Convention says that the U.S. laws exclusively govern the extent of protection here. Okay, there is some support for the idea of whether they own a copyright can be determined under Canadian law, but again, Veek acknowledged SBCCI owns their copyright in their code. It's not important. Upcodes acknowledged that it was undisputed that the model code drafter owned a copyright in their code. The question is whether they can come to a U.S. court and enforce it under U.S. law. That's the question. So if you take their position to sort of like a more extreme position, let's just say that Canada granted a copyright to a system. It changed their laws. It said, okay, we're going to grant copyrights to a system or a process. And it gave somebody, a Canadian citizen, a copyright in a process or a system. They can't come here and enforce that. That 102B prevents it. This court's position in Veek prevents it. How would that make any sense if, okay, so Canada gives you a copyright on a system, and you come here to the U.S. and you try to enforce it? In the U.S., that makes zero sense. We have our laws for a reason, and they frankly are not enforcing. They're not trying to enforce their Canadian judgments against my clients in this case. They talked about it. They said that they were thinking about amending their complaint to do that. They didn't. They still haven't. So this is a lawsuit under U.S. law, under U.S. copyright law.
So are these particular? Is this two different towns or?
You mean
Say A and B, and they're two different towns or one town or what?
Anna and Savoy, Texas? Yeah. I believe they're two different towns.
Two different towns.
I believe.
What was the process that they are alleged to have gone through to adopt all this?
Right, so the district
resolution of the town council or whatever governs?
The district court in Veek versus SBCCI, it's 49 F sub 885, said that Anna and Savoy, Texas enacted ordinances adopting SBCCI codes by reference. So it's referencing, just like the laws in Canada are doing it. They're just referencing the code. This is our law now. So then there was a reference to, this idea that, CSA can't do any quality control over the copies of the law that my client was selling. The same issue could have come up in ASTM because they're giving it away for free. And they're saying that they're giving away copies of the codes. And there was no real issue there with the ASTM courts with quality control. So, I'm out of time. I appreciate it.
Thank you, Mr. Gourley. It's been submitted.